Jerry River, Mr. Felton. For the commission before.
Can't hear you.
Procedural wise, I believe I would move to invoke the exclusionary rule. I don't know if they have any rebuttal witnesses or not, but they probably should be outside the hearing room. I also, there's a motion to dismiss. I would stipulate, and I think it'd be more effective if you wait till you hear all the evidence. That'd be a preliminary motion. Wait to hear the evidence, decide the motion to dismiss as well as the merits of the appeal, if that would be okay with the commission.
Okay.
One other, I know you have a packet of material from both Ann and myself. I would stipulate that those come in, maybe they do anyway, as evidence in front of the board, for the board, and for any apparent appeal. There's two packages for both of us. A lot of our duplicates, but I stipulate that those come in as evidence in the record. If Mr. Von Leach would agree with those stipulations.
Okay, Rob, you're gonna come forward and continue. I know we've been through this process with, revocation appeals before. Can you kind of lay the groundwork so the commissioners are back on the same page and tell us what we're discussing here today and why? And today, along with, Dag Ward.
May it please the board, Henry Ward for the record, Deputy Attorney General. I think in the packet, instead of just going back and getting my NRS, or excuse me, the NAC 501.185 procedure and burden of proof that specifically sets out the procedure in this matter. Without going into detail, you can go through the step-by-step from anywhere from 1 all the way down to 1 G subsection, H subsection I. If you do have the packet, I think from Mr. Wright, I think that might be the second last page for his exhibit number 10. So if all the commissioners have his exhibit number 10, I think that is the procedure that you must follow. If there are any other questions, I will be available.
Okay. The hearing needs to be called to order by the chair of the commission, so we are having a hearing at this point. We're calling to order the hearing.
If I may, for the record, Rob on H. Mr. Wright had basically a preliminary motion, and the commission needs to consider that. So that's an option for the commission, just to take that preliminary motion first and decide on that.
Okay. Commissioner Moore, I just address an issue before we get going here.
Thank you, Mr. Chair. I'm going to recuse myself from these proceedings since I do know the appellant, so I won't be participating in this procedure.
Okay, so we have initial motion that we need to discuss prior to going forward.
It may be heard, I believe we have an opportunity to argue on that motion. That's procedurally wise, that's why I suggested we hold that motion until the end of the evidence, because some of it's pertinent to that motion, in my opinion. proceed, I'm prepared to argue it.
And you gotta forgive me, I mean, we're not judges or attorneys or anybody like that up here, so we're gonna stumble through this a little bit.
On the record, Rob Bonamici, I'm comfortable with that, Mr. Wright suggested.
Okay.
What you read is there's a chance to cross-examine witnesses, and then if you read the particular statute procedure, then we have an argument after you examine the witnesses and the evidence. That's suggested because most of our exhibits is duplicate. We move that into evidence or into record, his package and my package. Then we'll address those, at least I plan on it, cross-examination of exhibits which are pertinent to the case.
Commissioner Macbeth.
I personally believe that we could save a lot of time if we laid out what it is this commission is supposed to do. We've been through this process before, and we know that when it comes to these license revocations, our jurisdiction, what we're tasked at is relatively specific. And it really only goes to, did the Department of Wildlife follow the proper procedure in the license revocation? And in the past, what we've done is we've just gone through to determine what the procedural aspects of the case and made sure that the department followed all the steps to revoke the license. And what I see in the documents that is being brought forth by the appellant is an attempt to relitigate what has happened in the district court, which was approved by the district court and litigated in the prior proceeding. And so, and since the judgment of the district court is final, and the appellant did not appeal it, his conviction is final, and trying to go back and rehash that conviction, the facts underlying that conviction, is not what we're doing. There's a legal concept called collateral estoppel that basically keeps the party that has been convicted from basically rehashing the underlying case, and I'm hoping the DAG will get up and confirm that that's what we're doing here, because I think we can get going down a road that we don't need to go to in this proceeding. We've got a conviction that is final, and we just need to determine procedurally what the department has done to revoke this license, and if once we hear all of the evidence on the procedural aspects of it, then that's when we make our decision. So if Dad could come up and discuss that.
May it please the commission, Harry Ward, Deputy Attorney General. You are correct, but we have to go back to NAC 501.185, and I'll read, quote, "The commission will use the following procedure." So we do have a procedure that we must jump through because the licensee does have a due process before this commission. So it says, the commission will use the following procedure in the order set forth in paragraphs A through I inclusive for a hearing, and that's what we're here on today, regarding a revocation or suspension. So those are the two options, whether it's going to be revocation or suspension of a license or permit ordered as per the provisions inclusive in any regulations adopted. Now, once again, as you basically said, if you find that the department did not follow the procedures going through the hoops, your decision is, they either did not or they did, and then you have the option as per whatever the statute says, if there's a revocation to affirm it or a suspension, whatever that is. To answer your question specifically, can you go back and relitigate the criminal procedures? No, but the appellant has the right to put this into evidence, and I would recommend to the commission that to allow this information or evidence in, but just to basically regard it based on what I've said as far as what your duty is under the NAC. And if you have any further questions, I will be available. And once again, like counsel said, Mr. Wright, it's more than willing, he can go ahead and waive his motion now to get all this evidence in front and then go to it and let him give his argument. And I would suggest that you just go through this procedure.
All right, so we need to, can you, Harry, I'm gonna ask you a question then. We need to take a motion on his motion? Is that what we need to do as a body here, or?
Yes and no. When he has a motion to dismiss, so this commission or the commissioners that are on the commission would then deliberate on his motion.
Okay, so he has a motion to dismiss.
But he said and I believe, and he can correct it, he says, because under D1, it's all preliminary motions. So he's filed a motion to dismiss. I think basically what Mr. Wright said, to expedite this, let's go ahead and hold off on the preliminary motion to dismiss and hear his argument at the end. Am I correct, sir?
That's correct. If other evidence has some bearing on that information.
Okay, so,
So therefore, I would recommend that, all right, the hearing has been called to order by you, Mr. Chairman. 2, the request for hearing notice of the hearing will be entered into the record. That's just for a record purpose, so that should be done. Then the commission may, on its own motion or that of party, exclude witnesses from the hearing. I don't believe there are any witnesses in this matter, but that's, I think council made that motion and to exclude it, but I'll let him address that. Then we go into D. The commission will consider any preliminary motions. That's number 1. Basically, he said he's waived that right now. Let's just get all the evidence before the board, then we'll bring up the motion to dismiss, and that's what the commission will deliberate on. Stipulations, I would ask the parties, do you guys stipulate to anything? I think Mr. Wright proposed a packet to you guys, so I would ask Endow, do you stipulate to the packet to this being evidence that this board can look at? Then you look at proposed orders that the department appellate may have agreed to pursuant to a settlement. I don't think that's before this commission. Then we go next to E, and I think that would be the department will present its evidence and then be cross-examined by the appellant. And then likewise, the commission has a right to ask questions. And just go through that, and I will be here if you have any need any assistance, but just follow this procedure.
so where I believe we're at is E, the department will present its evidence and be cross-examined by the appellant.
I think that's where we are.
Okay, so let's,
Based on the fact that Mr. Wright said he will waive this preliminary motion, and just let's get to the nuts and bolts of it.
okay, let's go there. Where the department will present evidence and be cross-examined by the appellant.
For the record, Rob Bonamici, Chief Game Warden. With regards to the state's evidence, we have, first of all, Exhibit 1, which is in your packet. That is NAC 501-200, which is a regulation that guides the department in the revocation of hunting, trapping, fishing licenses. And we'll be referring to that later as we go through the exhibits. Exhibit 2 is Mr. Felton's conviction in Elko Justice Court. And that conviction was for, in August 4 of 2010, for the unlawfully trapping on private property without permission, which is a 6 demerit point violation, and a conviction of failure to visit his traps, which is a 3-point demerit violation. It's also important to note that basically the individual, if it arises out of the same event, which we consider this to arise out of the same event, pursuant to statute, we can only assess demerit points, the highest 5 highest violation with demerit points. So whichever violation has the most demerit points gets assessed. That's the 6 points for the trapping private property without permission. And then we move on to Exhibit 3. That's out of Beatty Justice Court in Nye County. And that was for a conviction in March 16th of 2010 for another violation of failure to visit his traps. And that's 3 points. And then we move on to Exhibit 4, which is the recording from Churchill County, New River Justice Court of Fallon. And that one, there were 3 counts charged. You'll see that in the criminal complaint that was attached. And you'll also see the application for summons by Game Warden John Swisher. So as a result of that trial, where Mr. Fountain was represented by Mr. Jerome Wright, the court found Mr. Felton guilty of count 1, and that was a violation for fail to visit traps in which a desert bighorn sheep was caught and died. And then he was convicted of count 3, which was for fail to visit traps the year prior, basically. And in that, there was, count 1 was the year prior. Count 3 was failure to visit traps. There was no animal, I believe, caught in that trap, or those traps. In both counts, the defendant was sentenced to 15 days jail, 3 years probation, and then if no further Department of Wildlife violations, the jail time would be dropped, but he was fined $500. And then count 2, which was another count for fail to visit traps, was dismissed by the court. Then a letter in Exhibit 5 was sent stating that, let me back up a little bit here. In Exhibit 4, the count 1 and 3 convictions we deemed to be 2 separate events because they occurred, there was time split in those. So they were definitely 2 separate events and occurred in different areas as well, but both in Churchill County. And then on Exhibit number 5, we sent Mr. Felton a letter stating that he had 11 demerit points, and as the regulation requires, or actually the NRS, that we notify the defendant if they have between 9 but less than 12 demerit points. So that was done. Then Exhibit 6, Mr. Wright, Mr. Felton's counsel, sent myself a letter that in the first paragraph you'll see there at the last sentence. So either the court has the record incorrect and you picked up on it, or you have it down incorrect. So that caused me to go back through our records and double check everything. And after double checking everything, I indeed did make a mistake. Mr. Felton had 23 points, not 11 points. So a letter was sent to Mr. Jerome Wright, Mr. Felton's counsel, on January 8th, advising that he was subject to revocation, and we are pursuing revocation with regards to that issue. Now, when recalculating the demerit points, if you go back to Exhibit 1, number 4 in NEC 501-200, a person who is convicted of committing any 4 wildlife violations arising out of a separate event within a 60-month period will be assessed an extra 12 demerit points. So that's how the 23 demerit points was arrived at. continuing on to exhibit number 8. Mr. Wright notified the department that he was going to appeal the conviction and add an order of stay that you will see attached there. So we put everything on hold, obviously. Then exhibit number 9, the district court heard the appeal and made judgment upon that appeal and affirmed the appeal, basically stating that we're upholding the convictions that were rendered in justice court in Churchill County. And those were the count 1 and 3 convictions I explained earlier. Then exhibit number 10 was a letter through Mr. Wright regarding Mr. Felton and his revocation of his privileges since the district court had upheld the convictions. And then number 11 is a letter from Mr. Wright requesting an appeal, which we're hearing today.
Okay, so that concludes your evidence. By what I read here, you can be cross-examined by the appellant.
A little awkward. If you can hear me, I'll let you stand here.
Yes, sir.
One moment. Harry Ward, Deputy Attorney General. I've not handled these before you before, but in my other cases, we usually swear in a witness. So if you don't mind, if there's no objection by the commission, I'll just go ahead and swear in the witness by a typical oath. And if counsel, you don't have any problem with that?
No, and I'd stipulate you could swear in Mr. Felton at the same time.
Okay, so I'm going to ask all the witnesses to stand. Raise your right hand. Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
2 yeses. Thank you.
Thank you.
Mr. Bonamici, how long have you been with Endow?
Been with Endow for over 34 years.
Did you start out in the field?
Yes, sir.
Can we get a microphone so we can capture all this on the record?
Okay, yeah. Let me just try and sit over there. Would you like to sit?
Might be better.
Sit here if you would like. That lady won't bite, will she?
Not one bit.
If she does, me first. It would help me if I could sit right here. Absolutely. I just had eye surgery, so my eyes are out of focus. I couldn't keep my head down, and I got the glasses to change back and forth. Kept the perception of that. Mr. Bonamici, I'm just asking you about your background. You've been in for 30 years.
34 plus, yes.
And do they have guidelines and systems to train, I call them game wardens, but you probably have another name for them, in the field?
But they are game wardens. Yes, we do have mechanisms in place for training.
And the law and your guidelines are expected to enforce the laws uniformly?
That is correct.
And I guess they have discretion if they need to,
That is correct.
and that's up to the individual game wardens.
Correct.
So they can cite someone if they want to, or not if they don't want to.
Correct.
Are they supposed to cite someone as soon as they find an infraction, or can they wait for months or days to go do that?
It's dependent on the case, but yes, that is an option to cite immediately or do a little more investigation.
And you're familiar with Nevada revised statutes?
Not all of them, sir.
I think you became more familiar with this, as we all did after this appeal. In reading your correspondence, that's probably accurate.
Depends which statute you read.
Well, NRS 501.186, and that's exhibit for the commissioners here. Bear with me. Is in exhibit number 7 on my documents. And I apologize, I learned on the morning of March 7th that this was due on that date, so I took all my secretary and my wife and put together the package. I didn't have time to index it for you to get it here by 5 o'clock on the 7th, which is 14 days before the hearing. And in your exhibits, if you won't remember that, Mr. Bonavini, it would be, maybe exhibit 7, no,
I have the NRS.
That's procedure on how to establish points, is it not?
Correct.
And it sets out how you assess points, and it's 12 points, is that correct? Essentially, Exhibit 7 does that. NRS 501.186.
Could you?
By the revised statute.
Correct.
And it says in there that you can accumulate points, and 12
Correct.
points you shall suspend a license, right?
Correct.
Okay. It also provides a procedure for a person to go to school and remove points, is that correct?
That is correct.
Okay. And that's in paragraph 1.
That is correct, sir.
Now, you do know that Mr. Felton went to school, don't you?
Absolutely, I have a copy of his record where he attended under safety.
You never addressed that with Mr. Felton or on your, when you're telling your points in your correspondence to me, did you?
It was calculated in there.
It was?
That is correct.
Can I refer you back to exhibit number 7 in yours, the letter of December 12th, 2012. That's exhibit 4 on my documents, and exhibit would be 7 in theirs, the letter of Commissioners of December 12th. Exhibit 5. You have that in front of you?
Exhibit 7?
Yeah. The letter you wrote to me December 12th.
Yes, sir.
And that letter is where you tell Mr. Felton in December of 2012 that he has 11 points.
Exhibit 7, he has 23 points.
You're looking at a different exhibit than I am, man. Your letter of December 12th, 2012.
It's exhibit 5. Exhibit 5.
Oh, exhibit 5 in his? I'm sorry, exhibit 5. You have that in front of you?
Yes, sir.
Okay, now, do you know when he went to school?
Yes, sir. He went to school on 11/6 of 2010.
And when did he submit that to NDOW? He went to school a long time before he submitted it to NDOW. Is that correct?
That, I would have to check my other file. But I do.
Did you look in your file or give you a correspondence? Board members, I would tell you this is not in the exhibits. I do bring copies for you. If I may, can I come down the line? I got a copy for you, Luigi. I'd ask you to review that if you would. If you look at that, doesn't this appear to be a fax from Mrs. Denise Felton to your staff on September 18th of 2012, showing that he completed school long earlier.
Correct, it shows that he completed hunter safety on November 6, 2010. And I believe for the record, I just quoted from prior to that, I stated he completed school on November 6, 2010.
So school was completed before your correspondence of December 12th, 2012.
Correct.
But he never got credit in your letter to him where you show he has 11 points.
The point breakdown, sir, is as follows. For the conviction in Elko Justice Court, that was 6 points.
Chief Bonamici, could you give us a date on those? Are we, if we could maybe get 5 to step through that?
That's, I think that's in his letter, they say November 12th, which is exhibit 7 of mine, I believe 5 of his. And I'd also, I think they should move this correspondence into evidence for the record. Go ahead, Mr. Bonamici.
Okay, from the Elko Justice Court conviction of August of 2010, Mr. Felton had 6 demerit points. He had a total of 9, we assessed the highest.
I understand that, but if he goes to school, you get credit, do you not?
I will cover that, sir.
Huh?
I'm gonna cover that.
Okay.
And then March 16th of 2010, the Beatty Justice Court, Mr. Felton was assessed 3 demerit points. So that's a total of 9 demerit points. Then on November 6th, 2010, Mr. Felton attended hunter safety, thereby pursuant to NRS, removing 4 demerit points. So we have 9 minus 4 is 5 demerit points Mr. Felton has at this time.
Well, my question is, your letter to him on December 12th, 2012, where you reflected he had 11 points is inaccurate. You didn't give him credit for going to school.
Sir, I'm not finished yet.
Okay.
And then with regards to the conviction in Churchill County, which is our exhibit number 4, the state's exhibit number 4, Mr. Felton was convicted of 2 separate counts, therefore adding 3 demerit points for count 1, 3 demerit points for count 3. So 5 plus 6 is 11. And that's how we arrived at the 11 demerit points.
But no credit for his 4 points.
Yes, that includes,
You had 6 and 3 and 3 and 3.
we automatically gave him credit for those points.
Look at exhibit
For
number
hunter
11,
safety.
that's the last exhibit I have where I spelled out 3 and 3. Council, he would have referred to my exhibit number 11, which is my calculation on points. You can only get points for the highest violation of the citation, correct?
Per event, yes, sir.
So in Elko, there was a 3 point and a 6 point, so that would have been 6 points.
That is correct, sir.
Okay, and then in March of 2010, in Beatty, he got a 3 point violation.
That is correct.
Now, at this point in time, he'd gone to school.
On November 6th, yes, sir.
Right. So you subtracted 4 points, you would then have 5 points.
That is correct.
Now you come back to December 7th, and we're gonna talk about those convictions or not, whether they're merged because of the procedure that NDOW used and cited them in one complaint, like one citation, you don't take the highest points. So taking your calculations, you gave him 3 and 3,
Correct.
okay? And that makes how many points?
11 points.
11 points total. That's what your letter said.
That's what the first letter said.
And so, in December of 2012, you were of the opinion you only had 11 points.
That is correct on that.
And you also had that same opinion up until January 8th of 2013, after the appeal.
No, sir, prior to the appeal.
The first correspondence, if you look at your correspondence, we have correspondence of December 31st, which is letter of December 12, 2012, had 11 points. In your November 13th letter, which is Exhibit 2 on mine, Chambers, December 14th of 2013, you're telling me you accumulated 12 points, right?
On January 8th, 2013,
That's the first time you mentioned you had more than 12 points and you were taking these
yes,
points.
that is correct.
That was long after correspondence about points in an appeal, correct?
No, sir, the sequence of events was December 12th, 2012, I sent an 11-point demerit letter. On December 31st, approximately, would that be 9 days later, you sent me a letter stating that the calculations were incorrect. I looked at the calculations, and on January 8th, approximately 9 days after your letter, I advised you and Mr. Felton that you had indeed 23 points. The 23 points is predicated on NAC 501-200, number 4, a person who is convicted of committing any 4 wildlife violations arising out of a separate event within a 60-month period will be assessed an extra 12 demerit points. So 11 plus 12 is 23.
Let me ask you about that if I can. We have the Nevada Rice Statute, we have the Bad Administrative Code,
Correct.
correct? If they're in conflict with each other, which one do you think controls as far as the law?
If they're in conflict, the NRS controls. If it's a matter of specificity, whichever is most specific would control.
If you look at NRS 501.186, which is my exhibit number 7, members, that letter sets forth a couple of things, doesn't it? It tells how you accumulate points, that NRS does, and it tells you how you can go to school and lose 40 merit points, right? Correct.
Yeah.
In that particular correspondence, the date when you were writing me, you were of the opinion that he had 11 points, based upon NRS 501.186, which you set forth in your letter. You cite that. The first time you cite 500, 200 of the Nevada Administrative Code is in January, after the appeal. Is that accurate?
I'll have to look at my letter. The December 12th letter pursuant to NRS 501.186 is cited in that letter, and it is cited in NRS 501.86 is cited in the January 8th letter as well.
But your first letter of suspension was sent to me as exhibit number 2. It was sent to me in November of the 14th of 2013.
14th of 2013 letter cites both NAC 501-165 as well as NRS 501-186, as well as NAC 501-210.
And let me talk to you about that. I appealed that, correct?
You appeal the suspension.
Exhibit 1 on my members, on my exhibits. I appealed that on November 26, 2013. Certified letter to you November 26th.
Yes, sir.
Appeal, right?
Yes, sir.
Okay. And in response to that letter, you called me in December,
I believe so.
and you advised me that we had a hearing. You had a hearing in February in Las Vegas or in March in Reno.
Yes, sir.
And I advised you, when I live in Reno, my colleagues in Powell, we'll take the Reno date.
Correct.
Now, going back to that, this has to do with my motion to dismiss. You're familiar, we talked about it many times in here, NRS 501.1816. In particular, subsection 4B. So very pertinent to my motion, Chamberlain. Doesn't that statute say that the hearing must be held within 60 days after the request is received?
Yes, sir.
That didn't happen.
No, sir, based on your exhibit number 1, I think.
That would be correct.
Based on your exhibit number 1, as you stated on page 2, Robert Bonamici called council, right, and advised him that commissioners were meeting in Las Vegas, Nevada, in February and in March in Reno. Council selected Reno, Nevada, as his client lives in Fallon, Nevada, and this matter was set for the 21st day of March 2014. So it was done with an agreement with you.
Absolutely not. I didn't even know about this requirement until the 7th of this year, when I prepared the motions. And obviously, looking at your correspondence, you didn't either. It doesn't say the burden is on the appellant to set this case. It says you must set it. It must be, must and shall, or mandatory requirements, must be set within 60 days. So you could have set it within 60 days, I would assume.
Pursuant to NAC, and I'll have to look with regards to hearings and so forth, that the commission hears if both parties agree to an extension is allowed. In this case, both parties, yourself and myself, agreed to an extension.
I don't agree we agreed to it. You gave me the dates, 2 dates, none of them within the 60 days of my appeal. And I wasn't even aware of this 60-day rule until I prepared for this hearing on Friday the 7th. And in your correspondence, it showed it. There's a procedure for the chamber members. If you want a continuance, we can do a continuance. But I didn't request for a continuance. You never sent this within 60 days.
I attempted to do so, and even in your letter, which is my Exhibit 6, dated December 31st, 2012, at the present time, Clinton Felton does not have any points against him from the December trial, blah, blah, blah. And that might be the wrong. There it is. One of your letters you sent me asked me to please avoid the holidays.
That was on the very first appeal.
So if I was asked by you
And that was
to avoid the
November.
holidays, and I accommodated you, and I accommodated you with the Reno hearing as opposed to Vegas hearing,
Counsel, this is This is exhibit number 2 of my exhibits, and that letter is burned. I said, please, with the Christmas holidays coming up, my trial schedule and vacation plans, call my office and spoke with me regarding a hearing date to accommodate my calendar, and also advise me if the hearing will be held at 1100 Valley Road or some other location, I'm assuming Valley Road. You called me in December in response to that letter and gave me 2 dates.
I think the appropriate language, the critical language there is accommodate my calendar, which you've stated.
After the Christmas holidays. 60 days, which is the requirement of NRS 501.1816, must be set within 60 days. That's your burden. You know you have the burden in this matter, correct?
Yes, sir.
And it doesn't say that county is a procedure after it's set. But NRS 501.186, advice exhibit number 7 is clear. The hearing must be held in 60 days after the request is received. Anyway, that didn't occur, right? Didn't get set within 60 days.
It did not get set within 60 days due to an agreement that you and I had.
We didn't have an agreement. You testified, which is accurate. You called me in December, a month after my letter. I think December 20th is the first phone call. I called you back on December 23rd. I think on December 26th we communicated. And that's the first date that you told me that we could have a February hearing or a March hearing in Vegas. And either one of those dates have been outside of 60 days.
That is correct.
So that violates what the law says you're supposed to do in setting this matter for hearing.
All this was done pursuant to an agreement, and I know my word is good. I would hope yours is.
Well, you want to see my notes on the phone call, the play when I called, and I'll swear myself in. I didn't agree to that. There's a procedure for stipulation to continue. The conversation was this: you can have a hearing in Las Vegas in February, and you can have a hearing in March. And I believe that this commission actually had a hearing in January 8th or 9th in Las Vegas.
The meeting was January 31st, February 1st in Vegas.
All right. That would have been within 60 days.
Correct.
Actually, it wouldn't have been within 60 days. From November 26th to December 26th to January 26th, that date wouldn't have been within 60 days. You agree?
I agree.
Now, let's go back to the NRS 501-186. You've told me that the NRS's control over the administrative code. Right?
In general, yes.
The NRS 501-186 talks about going to school and losing 4 points. Then you go to that administrative code, and it adds some stuff.
Correct.
Okay, and if you look at your correspondence, you weren't even aware of that until November, long after the appeal. In December and January, you started bringing up the thing about 4 convictions. So, in my opinion, reading your correspondence, you weren't even aware of that law until you got digging into it to control this appeal. Is that be accurate?
No, sir.
You're familiar with the laws then, the codes, correct?
Correct.
You get information about traps being unattended for 70 days, you didn't investigate it?
What do you, I'm not sure what you're referring to, sir.
I'm referring to some information you received about, I'm talking about uniform enforcement of the laws. As you know, some of my contention here is that Mr. Swisher abused discretion in writing up a ticket for Mr. Felton for checking traps that weren't even his because he offered to help his son who was sick. And yet, I know there's information about traps being left unattended, no one went out and enforced that.
That is incorrect. Mr. Felton did send us a letter, but I think more appropriate, this is not the time and place for this discussion. This matter is involving the demerit points, whether we assess the proper amount of demerit points, and whether we followed the process, and Mr. Felton was indeed convicted of those crimes.
And it's your opinion, that even though he didn't say it was within 60 days, that you followed the rules?
Yes, sir.
And it's your opinion, even though NRS 501.186 controls over NAC 500.200, that you want to look at NAC 500.200? That's your position?
Yes, sir.
I have no further questions.
Okay, so that concludes E. So the appellant will present its evidence and then be cross-examined by the department.
I should ask you any questions of this witness, or is he kept on?
Is there any questions of the commission before we move on? Okay. The appellant will present its evidence and be cross-examined by the department.
Call Mr. Felton to the stand. Please state your name for the record.
My name is Clint Felton,
How long have you been trapping, Mr. Felton?
28 years.
Does your son trap as well?
Yes, he does.
And we've hashed over the matters in Fallon, Churchill County.
Yes, you have.
The judge convicted you of count 2 for being 2 hours and 20 minutes late for your son called you sick and actually check his traps.
He did not.
He called you and you checked his traps.
That's correct.
And Mr. Swisher met you there and gave you a citation for not only not checking the traps on that date, but not checking the traps 4 days previously.
That's correct.
And the judge found they weren't your traps, so he convicted you on that.
That's correct.
Did you also have occasion to pick up traps for a farmer at his request?
Yes, I did. A rancher called me, advised me of the traps, and I went and collected them.
So the judge said you didn't go back and tell the rancher that you'd picked up the traps to protect his dogs, and he thought they were your traps.
That'd be correct.
So you got convicted of that too.
Yes.
When did he write you up for that offense? Did you ever get a citation for that offense?
Never did get a citation.
How did you occur, you got a citation out in the field when you were checking the traps for your son?
Yes.
And then, did your son get a citation for the same traps,
He did, but later date.
days later?
Yes.
And the first time you knew that they were accusing you of count 1 of setting traps, which are probably 2 years old in the Stillwater Reef, where'd you first time find out about that?
Not until the next year.
And you served a complaint with the DA's office.
That's correct.
And that complaint, it combined several counts, three dates and charges,
Yes, I did.
in one complaint.
Yes, one complaint.
And we went to trial on that. Correct?
Yes, we did.
Okay, now, you've heard Mr. Bonamici's testimony about school.
Yes, I have.
Tell me about your going to school.
I went to school in 2010 and then sent in a letter in 2012 to get credit back for those points.
Did you ever get credit for those points?
I called his office twice in the last 4 months and asked for my point totals, and it was denied.
Never gave them to you.
Never would give them to me. No.
Did you have a conversation with them not too long ago, once again asking for those points?
Yes, 4 days prior to this hearing.
And what were you told at that point in time?
I was told that to have an attorney contact me. They're not
Were you
doing-
told by Joanne, I think her name was, she couldn't talk to you?
I asked her first, and she referred me to Mr. Bonamici.
So they've never given you any confirmation you went to school?
No.
And the information I gave you, which is the last exhibit I provided to chamber members, is your record of faxing that in to M-Town.
That's correct.
Now, after you got to notice your 11 points, that's when you went to school.
Repeat that again?
After you got notice from NDOW that you had over 9 points, that's when you went to school.
Yes, that's when I sent the school credited.
And you've been trapping how many years?
28 years.
I have no further questions. Bonamici?
For the record, Rob Bonamici, Chief Game you took Hunter's safety before you received the letter from myself, the first letter, or after?
I would have taken to which count are you referring to?
The 11-point letter sent to you,
I would have taken it before that.
so you did indeed were aware of Hunter's safety removing 4 demerit points, correct?
No, because your office never confirmed it with me. I know I took the course, but I did not know I received credit.
For which purposes did you take the course?
I took the course to inhibit my privileges.
To remove
To
4
remove points, yes.
To remove points, so you were aware that you took the course to remove 4 demerit points.
Yes,
And then afterwards, you received the letter, and with the points designated in that letter, if you had calculated, would have showed 4 demerit points were removed, correct?
no, not the first letter, the second letter was referred to.
Okay. And is Mr. Wright your attorney?
Yes, he is.
So he represents you in all matters regarding this case?
Yes, he does.
So do you think it was inappropriate for me to refer you to have Mr. Wright contact me for your records?
I believe you're a public servant, and if I ask for something, I'm a sportsman, and you should obligate me.
So as a public servant, when I arrest somebody and they invoke their Fifth Amendment rights, I can continue to interrogate them.
It's irrelevant, there's no Fifth Amendment rights here. In fact, I believe this is more civil procedure than criminal. I'm not certain what the rules are.
But in both cases, I'm a public servant.
I was stipulated he had permission to get records from you, which you're supposed to control from him, which you sent in. That's why he went to school.
You are his attorney.
Yeah.
And once an
And he certainly had
individual
my
obtains
permission
an
to call you and get his records.
Did you send me a letter in writing authorizing him? Thank you. No further questions.
Have you ever had any notice whatsoever that they gave you credit?
No.
No further questions.
Any questions by the commission?
Mr. Felton, they might have some questions, sir.
Excuse me.
Any questions from the commission? Okay, seeing none, we're gonna move on to G. The department and the appellant will present any rebuttal evidence and then be cross-examined by the other party and questioned by the commission.
For the record, Rob Bonamici, Chief Game Warden. I believe the state has laid out their case fairly clearly. It is clear Mr. Felton did obtain these convictions. It is clear that he did appeal his conviction in Justice Court in Churchill County. It is clear the district court upheld those convictions. We're not here to retry the case, rehear the facts surrounding that case. The math doesn't lie. We did subtract 4 demerit points. Mr. Felton is also, prior to him obtaining Mr. Wright as his attorney, did call me on multiple occasions. And I can't specifically tell you the dates and times, but I'm sure if you ask Mr. Felton, he will confirm. He will tell you that.
I object again. Let's talk about in the final argument what the evidence was in front of the commission. I'll stipulate you can elaborate if you want me to about the convictions. I'll be happy to do that. If you want to expand closing argument, I'll stipulate with you to go beyond the evidence in front of the commissioners.
Will you stipulate to the officers' reports with the photos of
Absolutely not. They're
the
nothing to do
lake?
with the record.
The lake.
Nothing to do with the record. And
No,
you already addressed that in your
Right.
opening, which is in violation of what the record was.
Okay. Seems like we're just arguing, we're going nowhere. Let's try to.
Okay, the evidence is clear. I mean, the math doesn't lie, the convictions don't lie. Mr. Felton was indeed convicted. of those crimes, the points were assessed properly. And therefore, the state requests that the commission uphold the revocation.
Okay, now, does the appellant have rebuttal evidence?
Nope.
No? Okay, closing arguments.
That's what he just did.
What's that?
That's what he just did. That was your closing argument, was it not, Mr.
Yep.
Amici? I want closing argument.
Okay, your closing argument.
Harry Ward, Deputy Attorney General, I think you are correct, the procedure was, I don't think any party had any rebuttal testimony, and what you heard was the closing argument by the department. I think it's appellant's closing argument, so I think we are down on letter H. I think that's correct.
I would agree with that.
All right.
This will be short. You all know my position in reading my history and my attitude about these convictions and how I feel. Even the judge had an attitude about Mr. Swisher and the road delays and so forth. That's water under the bridge. What's not water under the bridge is the statutory requirements to follow the law. And in this case in particular, NDOW has a burden in this case. I don't have any burden. They have the burden to convince this board that everything was done properly on this appeal. To that end, there are two big issues here, and I harped on the length, trying to make a point that's clearly understood. And that is that NRS 500-1816 provides a statute for setting out the way you administer points. Then you get into the Nevada Administrative Code, which is NRS, not the NAC 500.200, where they start tacking on 4 convictions and extra points, kind of a penalty if you get 4 convictions. That's in conflict with the statutes and the statute control. Mr. Bonamici agreed with that. So based upon the statutes and not trying to bootleg further points and further violations under the administrative code, which is not applicable when they're in conflict, he does 11 points. He can't lose his license. Now, going one step further, part of my argument about them having cited him for 2 hours and 20 minutes late for checking traps for his son who was sick and weren't his traps, they want to use that to take this man's, a big part of his livelihood for 3 years. Yet somehow they want to say, because I requested to get past the holidays, call me with a calendar, and we'll set it. He called me up in December and set this case, give me a choice. February, what I remember, but apparently it was January 31st and February 1st, and then March 21st in Reno. I took March 21st, unaware at that point in time that this matter must be set within 60 days. That's clear. That's his burden to set it within 60 days. He could have said it and says, here's where we're going to set it. In fact, there's procedure in your code to have special sessions as necessary. I think you meet 9 times a year between here and Las Vegas. And the last time you met was this last meeting that you just approved the minutes for. There was a hearing in January. Even if you set it at that hearing, it would have been outside the 60 days. So we would have had to set this within 60 days on a special hearing, or set it and got me to continue it or set it. He called me up and gave me 2 dates. I get ready to prepare my motion on the 7th of last month, and I'm reading this procedure because I've never been here before. And I'm reading the procedure and what you do and present, and I hustle to get my exhibits into you 14 days in advance without index, which I apologize for. I got them there at 5 minutes to 5. In fact, I called Mr. Bonamici to ask him when they closed their office to make sure I complied with the 14 days. So they want to nitpick at him over being late on a muddy road by 2 hours and 20 minutes. They want to bootstrap themselves up on a complaint where they combine charges without giving Mr. Felton a citation, so they have a trial with a JP who almost always does with the judge, with the DA's one. I can tell you that. Have you ever tried any cases or been in front of them? JPs do that. Be that as it is, we lost that. But we haven't lost the right to have this matter set within 60 days, which he didn't do. And Mr. Felton has a right to have the NRS control over the code. Based upon those 2 facts alone, I think this board has to leave him alone on his license. He has 11 points, and that doesn't lose his license. And I want to thank you for your time and attention. You've been very patient. A lot of the crowd out here has had to wait through lengthy lawyers and their cross-examination, but thank you.
May it please commissioners, once again, Harry Ward, Deputy Attorney General. Now we would move on to NAC 501.185, letter I. The commission will deliberate And when I say deliberate, since this is an open meeting law, you can't go back behind the closed doors, so you have to do it in open, as per the open meeting law. The commission will deliberate and then render orally its order with separate stated findings of fact and conclusions of law. Now, right below that, there was some discussions, but I'm just going to read the NAC. The department has a burden of proof in a hearing regarding a revocation or suspension of a license or a permit ordered pursuant to provisions of chapters 501 through 506, inclusive of NRS, and any regulations adopted pursuant to those chapters. So at this time, I would encourage the commission to start deliberating.
Commissioner Macbeth?
Did we have an opportunity to talk to Mr. Wright after his closing?
Not after the closing.
All right.
Not correct. You would
I
not
wouldn't
have.
mind if you want to reopen the meeting, I'll answer any questions you got.
You do have some discretion. I think if both parties would have, consent to that, I don't think, you do have you do have that discretion. In other words, to going back to reopening the hearing.
Is that where we're gonna go? You wanna reopen the hearing and ask Mr. Wright a question?
Yeah, we're gonna
Commissioner
have to
Macbeth?
go. Question.
Okay,
And I would put on the record, as long as the department doesn't have any problem with that, then it would be permissible.
As, for the record, Rob Bonamich, I don't have a problem with that as long as we have an opportunity to amend our closing.
And possibly even cross-examine the responses to the commission, which would be appropriate.
okay. Mr. Wright, will you come up, Commissioner Macbeth, ask some questions?
And if I may, I might add that there's a particular statute, if the lawyer knows he's going to be a witness, he can't represent the client. I didn't know I was going to be a witness in this case. Apparently, now I am, unless it's a procedural question. Before us now is did they follow the law? And I have a motion to dismiss based upon NRS 500-186. But I'll be sworn on what your questions are, sir.
Okay, you've raised 2 points, right?
Two main points.
Two main points, okay. I want you to walk us through the first point. And I want you to get, because first of all, this is incredibly confusing. You guys didn't get together and have a joint set of exhibits. And so, it was hard for me to follow exactly which exhibits you were referring to. But with regard to the first point, your first main point, tell me what it is and point me to the exhibits.
I'll hit my exhibit file. Excuse me, turn my back on you.
May please, once again, Harry Ward, Deputy Attorney General, maybe we could approach this as council's motion to dismiss
That's what I was intending.
in regards to his original motion. In this way, he's not a witness, he's just giving argument based on his client.
That would be
Okay,
correct.
counsel?
That motion is in my motion to dismiss, was the first document in my file. And that addresses what I've marked on NRS 500.1816, which is my exhibit. So I got their file here. It's my exhibit number 7, and that's a statute that requires them to set this within 60 days. And I attached some points of authority to that motion to talk about shall. When initially I thought probably said shall, but it says must. Shall and must are kind of mandatory requirements in the law. May is discretionary. If you must do something or you shall do something, that's a directive. And in this NRS, which is my exhibit 7, and I think if I remember their exhibit 5, but it's the NRS 501.1816, which set forth about points, okay, and talks about that the hearing must be held in 60 days after the request is received. My mailing for the appeal, request for the appeal and to hear in front of the commissioners was dated November 26th. In my calculations for you in the motion, I took 3 days for mailing because I didn't have a return certified copy when they received it. They might have received it on the 27th, but they certainly received it before the 26th of November. And so pursuant to this statute, and that's why the motion is making, I'm sorry, you want to?
Yeah, hold on a second. Okay, so if we're gonna deal with this one first. And the letter, I'm looking at the state's, Indal's exhibit, I believe it's 10, looks like it's cut off. And the letter is dated November 14th, 2013. Is that not the letter by which the 60 days runs?
No, that 60 days, that's a notice to Mr. Felton through me that they were gonna take his license. I had 30 days to file an appeal to that. And then I filed a notice of appeal on November 26th. And that exhibit, if you got my file in front of you, is it my exhibit number 1? It's the first one. And that's a statute that would require the commissioner as a burden procedurally, which you talked about going into this thing. You were the one that said you don't want to get into the facts about convictions. Because procedurally, they failed to meet the law and sentenced within 60 days, which they easily could have.
Okay. The order affirming judgment is dated November 5th of 2013. And so then there's the letter of November 14th, which is within 60 days, and that addresses NRS 501.18163. Says not later than 60 days after the department determines that a person has accumulated 12 demerit points, the department shall notify the person by certified mail that the person's privileges will be suspended or revoked.
That's correct.
Okay, and so,
Read further if you would, please.
okay, I'm
Okay.
gonna go one step at a time. So that's what the November 14th letter is.
Correct.
Okay, so we meet the requirements of 3, right? The
Yes.
The department has met the requirements of 3.
I agree.
Okay. Now, what is, okay, so number 4 says, any person who receives the notice required by subsection 3 may submit to the department a written request for a hearing before the commission not later than 30 days after receipt of the notice. So let me think about this. Any person who receives the notice, that's your client.
That's me, that's certified to me, copied to Mr. Felton. I received that November 14th.
May submit to the department a written request for a hearing for the commission not later than 30 days. So where's your letter?
My letter would be, in my file, it's a November 26th letter, Exhibit 1, and that was addressed November 26th, the date on it.
Okay, so that's within the 30-day period that you have. That's correct. And so that is
That's number 4.
the flush language on 4. So then it says, if a written request for a hearing is received by the department, the suspension or revocation of the license, permit, or privilege is stayed until the determination is made by the commission after the hearing.
Right.
And then B, the hearing must be held within 60 days after the request is received.
That's correct. That request was received 1, 2, 3, 4 days after November 26th. So that means within, if you take November 29th in my motion, I calculated those
Okay, so
days.
the date of, so when was the letter
November 26th was the date my letter was mailed.
mailed? Okay, so when was it received by the,
I didn't have the certified return from them. The last letter was the next day, but there's a statute in there. If you mailed something that's presumed to be received, and I did receive it, you take 3 days for mailing, and if there's a time limit, if the time is less than 10 days, you don't count weekends or holidays, you get 3 days for mailing. I'm sure they received that on the 27th or 28th, but I didn't have that return receipt from the post office, but I mailed it on the 26th, they received it. They would have received it by statute within 3 days from the 26th, so by the 29th of December, they should have set this hearing. This hearing should have at the very least been set before your January 31st hearing, February 1st hearing. And in particular into March.
does the department have, anything that shows the date that the letter was received?
For the record, Rob Bonamici, we have a letter received from Mr. Jerome Ray on 12/4/13.
12/4,
of 13.
and is that an exhibit that you have?
That is in Exhibit 11. in the state's Exhibit 11. You could see that the letter was postmarked November 27th, so it was not mailed on the 26th.
Okay, and who wrote the received 12/4/13?
That appears to be written by Suzanne Scorpio, our executive assistant director.
When was the commission meeting?
First of February. It's the next one in line.
Based on this December 4th date, we could have set the hearing for the February meeting.
We could have, except for the request not to.
That'd have been 58 days.
Okay, so I guess I've got the facts nailed down on that one. So let's set that one aside, and I'd like to understand the facts on the other one. The other point that you made.
The other point I make has to do, once again, with the statute, NRS 501.186, which is a Nevada right statute. In my exhibits, that would be exhibit number 7, which we've been talking about. Same statute, you had it with you before, Councilman. And that's one where they talk about accumulate 9 points but less than 12. The department shall notify that person of the fact by certified mail, and then he can get 4 demerit points removed. I'm assuming there was a letter to that effect, because Mr. Felton went down and went to school and reviewed for more 4 demerit points, found out he hadn't got credit for it. Then in September, he faxed him that exhibit I gave, the last exhibit, telling him, hey, I went to school. And then by that time, their position was he had 12 demerit points. But what I'm saying is this statute talks about 12 points and 11 points. It doesn't stack on an additional penalty that the Nevada Administrative Code does, and it sets out the points, and that's exhibit number 10, I think. Maybe exhibit number 11. And that's one Mr. Bonamici keeps talking about, because that administrative code says if you have 4 violations within 5 years, we can take your license. Or if you have violation of points, we can double your points and add 12 points to it. My contention with that is the Nevada revised statute, which talks about 11 points and 12 points only, and then initial correspondence from Mr. Bonamici, that's all he talked about. After the appeal, but I think he, like I, probably read NRS 500. Nevada Administrative Code, 500.200, and then he said, oh, by the way, we're going to tack on 12 points and 4 points because Nevada Administrative Code says we can. So my position with that is, pursuant to NRS, which controls over NAC, which Bonamici admits, my client should not lose his license. He has 11 points. They can't tack on the penalties in this case.
Okay, hold on. Okay. The letter, what is the date of the letter? So we have a letter dated December 12th of 2012. Setting forth, it sets forth the violations. And it makes a statement that your client has been assessed 11 points.
Correct.
Doesn't really do a calculation for us.
Well, it shows the NRSs. that, you're right on that. It says he has 11 points, and there was still no credit for school at that time, is my position, when they wrote that letter December 7th. But your answer correct. Is December 12th of 2012, they're telling me you have 11 points, and you accumulate 9, you can go to school.
Okay, it says if a person accumulates 9 or more demerit points, but less than 12, the department shall notify the person of that fact by certified mail. That is the letter of December 12, 2012.
Yes.
And then it says, if after the department mails mails the notice, the person presents proof to the department that he or she has, after his or her most recent wildlife violation, successfully completed a course of instruction in the responsibilities of hunters approved by the department shall deduct 4 demerit points from the person's record.
I agree, and that is the exhibit, the last one I gave you, was where finally, Mr. Feldman's testimony was he didn't get credit for it. On September 18th, 2012, he mailed him in a notice about his 4 points.
Now, was the letter of December 12th of 2012, was it before you filed the appeal to the district court?
Yes, the appeal was in November 26th of 2013. After this letter came, there were no more violations, but then after we got through with the appeal from district court and try and get a new trial, et cetera, then when that came down, is when the first indication I ever had, and Mr. Felton had through me, is that Nevada Administrative Code 500.200 allows them to tack on extra points.
Okay, well, let's don't talk about that.
Okay?
What I'm trying to wrap my head around is, at the time, the December 12, 2012 letter, it's referencing count 1 and count 2, December 7, 2012, and both of those on December 7, 2012. Are those the same counts?
No.
These are separate.
Correct. I mean, my position on that was, like you write a citation, if you're speeding and you get a DUI and a reckless driving and you cross a yellow line, an officer can write you up for 3 violations if you only get the most points for 1 of them. And NDOW does that. But what they did in this case, and that's part of why I added the testimony from Mr. Switcher, which is exhibit where he says that they chose to put those together. I can point out that testimony for you. It's always been my position, by doing that, they had 1 complaint, they want to take the most points and the highest conviction of that, just like in the first case you have where they have April 5th and August 5th in Elko, you're going to take the highest one. And so when they chose to combine those to go to the DA and never give them a citation, they should be locked into only the highest point in that conviction, which would be 3 points.
Show me December 12. Show me those count 1 and count 2, December 7, 2012 violation. What is that pursuant to the citations?
No, one of them was. And that's it for, I think the dates, well, I'll tell you what the dates were. Let me get it here. Exhibit 8, or 7, let me look at Exhibit 8. Now this is where Exhibit 8 is where Mr. Swisher says they combined the 2 citations. I wrote in February with additional case on top of the Stillwaters. They never got a citation for that. Count number 1 was traps that were left, and a rancher called Mr. Feldman and said, I found some traps. I know you're a trapper. They roped together. I know you're a trapper. You mind, there's some traps up there. Do you want to get them? Feldman went up and released them. He didn't take them, so they weren't his traps. But he released them, and when we went to court, we had lots of testimony about the traps weren't like Mr. Feldman's because it's a distinctive trap. But the judge decided because Mr. Feldman didn't go by and tell the rancher, Mr. Estes.
Okay, time out. Direct me to the citation, or is there a judgment from the court on these? Did these go
Yes.
to court?
Yes.
But they're unrelated to the ones that went on appeal?
No, they're the same one.
They're the same ones?
Absolutely. That's what the appeal was all about.
So before that was final, the department sent this letter? Is that what I'm hearing?
I can't tell you when that appeal ran, it's in the exhibits.
The district court, order was in 2013.
It was a long time after the appeal.
2013.
It was a long time after the appeal. The judge said on it, what happened is, Mr. Felton hadn't lost his license. He called me and says, "You've still got a license. You can go trap if you want to. Trapping season's October to February." When they found out, they being NDOT, he got a trapping license, which he had a right to do. Somebody called the DA's office, and Judge Estes then made a decision within 5 days and that date. It set up in front of Judge Estes for a long time before it came down. I could probably find you when the appeal was, but I think it's in Mr. Bonamici's record. It was 6 months, maybe 8 months, a long time before the decision was made. And I know what triggered the decision. I just told you. That's not for the record, but yeah, that's what happened.
Okay, I guess what's confused me, if first of all, I thought it was count 1 and count 3 that he was convicted on, right?
That's correct.
This letter says count 1 and count 2.
I wrote Mr. Bonamici a letter about that, and he stood corrected. That's in the evidence, and he said, "You're right, Mr. Wright, I made a mistake." I was mad because I made the newspapers. It was incorrect in the newspapers.
But I guess where I'm confused is, what is the significance of the December 7th, 2012 date?
The December 7th, 2012 case, that's the date that Judge Lowry convicted him of count 1 and count 3 in justice court.
Justice Court.
Right. That's the dates in justice court. In fact, I've
And
argued,
those were appealed?
yes, they were appealed to district court.
And that appeal wasn't final until the November 5th of 2013?
Correct. That's probably about the date. I can look it up, but that's accurate. It took that long for the judge to decide it after it was submitted to him.
So I guess in my mind, I'm wondering if this letter here was premature.
It's what?
It-
Oh, there were some premature letters yeah, in fact, I addressed that with Mr. Bonamici. I said, "Hey, he hasn't been convicted. You know, you go to the newspapers and you say that, we got an appeal." He acknowledged that and held off. There's some correspondence in January of that year where I told him, "You can't take his license yet. It hasn't been a final decision. You got to stay everything," and that happened. And so after Judge Estes made his decision,
Okay, so this doesn't mean anything, does it?
huh?
Does this mean anything?
To me, no, it's an inaccurate correspondence, except it shows the state of mind of Endow that he had 11 points only, total, including the December 7th thing, and not the points he wants to give us now at 23. It shows Endow thought he had 11 points, and that's where I think it ends, but they want to tack on the NAC to add 12 points to him.
How many points? Okay, if this letter is premature, then I'm wondering on NRS 501.1816, does that even apply? How many points did Mr. Felton have on November 5th, 2013?
My position,
Because at the time, because if I take those off, if I take the last two counts 1 and 2 in this letter, or the December 7th, 12th as being premature, then he has 6 and 3, so he has 9.
correct.
So the statute says if a person accumulates 9 or more demerit points, then this letter comes out. So it's really what is on this letter with regard to the December 7th, 2012, which we now know is probably premature, is really irrelevant because there's 9 points with regard to August 5th, and March 16th violations.
That's my position.
Okay, so the letter gets sent, and then he comes back with his hunter safety course, and so now we're 9 minus 4, we're at 5.
I think,
Okay, so there's been no suspension. He's now good.
yes,
Is that where we were?
I would agree with that. But his hunter safety points, for the record, came in September of 2012. Well, that would have been before this letter, that's right. It was September of 2012 when his removal of points went in record. So in September, before the December 12th letter, he had removed his points, but he didn't get credit for it.
Okay. Okay, I think I've got these facts here down now, but on November 5th of 2013, counts 1 and counts 3, the judgment of the district court becomes final. And we now have 3 and 3.
Well, 3 and 3, and let's take my argument that you only get the maximum points because they combine them when they file a complaint. Just like on a citation, if you have 4 or 5 violations, they take the highest points. And that's represented in the first one in Elko. He got cited for trapping on private property, which is 6 points. And he got cited for not checking his traps, which is 3 points. And most points he got on that was 6. But they're trying to use that as 2 convictions pursuant to this NAC, which I have contention with, 500.200, where they want to tack on 12 points to punish him for 4 acts in 60 months and take away this man's license who's been trapped for 28 years. That's my argument about that.
Okay, so now I think I know where I'm at now. Where I'm at now is I am to November 5th. This is the way I'm working through these letters, these notices. The December 12th, 2012 letter, I think, is premature as to counts 1, the December 7th charges.
That would have
They
been.
weren't final, and so that is 6 and 3. And Rob, I'll give you a chance to try to explain it to me. But that's 6 and 3 and 9 is 9. I take out 4, I'm at 5. Okay, now, November 5th of 2013 comes along, and we get the final orders on the, so instead of it being December 7th, 2012, what it really is it's the 5 plus 3 and 3 is 11. We're at 11 points on November 5th, but now we need to deal with the issue of the tacking on of the 12 points. Okay, so, but was there another letter pursuant to 501.1816(1) on November, because he doesn't get any more chances that they, of having hunter safety apply anymore. So I'm wondering if that even applies. He's had that opportunity in the 5-year period, in the 60-month period. So I don't think that the department had an obligation to set out an additional one once he reached 11 there. They are making the determination of the point total now based on the adding the additional 12 demerit points. Okay, so what that's an NAC that does that?
Yeah, it's Nevada Administrative Code.
And what is where is that from? What's the exhibit?
It's in here, I think it's
Exhibit
exhibit where?
Exhibit 1.
One on Mr. Bonamici's. Mine's a different exhibit. It's a lengthy one, it gives points. You gotta turn to the last page, it's about 3 pages. In the paragraphs, on the back end of it, there's some paragraphs that talk about 4 violations, and it talks about, they can tack on 12 points if they have 4 convictions of 5 years.
Okay, so now I'm just gonna go by NAC. I'm not dealing with any arguments about statutes versus, NACs, okay? So I'm at 23. And then they send the letter. Now we're back to the other letter and the 60-day period. Okay, so I've got the facts. Rob, so council, thank you very much for walking me through that. I appreciate it.
I appreciate your question.
Rob, did you want, I guess what I want to hear is with regard to the December 12th, 2012 letter that NDOW sent, those last 2, in my, it appears to me that those are premature on that letter. What is the, what am I missing? What are we missing?
they're not premature from our perspective because we were totally unaware that Mr. Felton was gonna appeal, his convictions. So, once we were notified by, Mr. Wright that, Mr. Felton was appealing the convictions, that's when we had conversations, and there wasn't any issue from either party that, okay, we'll stay it. I mean, and he applied for a stay and did everything. So the letter came out before NDOW was aware that the convictions were going to be appealed. But the math still adds up the same.
Yeah, I realize that, but I guess from a standpoint of, just procedure, generally, and this is administrative, what would normally happen is that after the convictions in justice court, you know what his notice of appeal period is. And that the department probably should have waited until that expired to issue their letter. Because until until his notice of appeal period runs, that justice court decision is not final. And the department should have waited to issue it. But I don't know if that enters into this anymore. I'm at, looking at the NAC and adding the 12 to the 11, I think I'm okay procedurally where we are.
For the record, again, Rob Bonamich, I understand where you're coming from on the 30-day appeal, but in the same NRS 501-186, number 3, not later than 60 days after the department determines that a person has accumulated 12 demerit points, the department shall notify. So we have that 60-day window as well to comply with. We just try and, as a matter of course, and that's how we've been doing business, and it can be changed, it may not be the best way, but as soon as we're notified at our earliest opportunity, we try and get a letter out. So we're not pushing up against that 60-day. And then with regards to the NRS superseding the NAC, I'll read you NRS 501.1817 in its entirety.
Do we have that in front of us?
No, that's what I was going to read to you, entirety. Then it's short. Any person whose license, permit, or privileges has been suspended or revoked by the department pursuant to NRS 501.1816 is entitled to judicial review of the decision in a manner provided by Chapter 233B of NRS. So we continually work with 233B with regards to our regulations and so forth. And it's not uncommon for the plaintiff and the defendant to get together and extend processes, appeal process, dates, what have you. And then under NRS 501.1818, the commission may adopt such regulations as are necessary to carry out the provisions of NRS 501.1812 to 501.1818 inclusive. So there's direct authority for the NAC that Mr. Wright is referring to and claiming that the NRS supersedes that. So that NAC is at the direction of NRS under the authority of NRS.
You mean adding the 12 points? Yeah, I don't think that this commission is going to tackle whether or not there's a conflict between the NAC. The NAC is the law, and if council wants to, appeal it, I guess that's the way I look at that. So I'm not talking about that. I'm talking about the 60. Now what I'm talking about is a 60-day period under NRS 501.1816 4B. Says the hearing must be held within 60 days after the request is received. Okay, and just with the evidence that we have, we know that the letter was received in the department's office on December 4th. The council didn't bring any certified mail receipts or anything to counter that, And so that's the only evidence that's in front of this commission is the December 4th date. We could have set the hearing on the January 31, February 1 commission period. But now is the issue of, did you have an agreement to extend? And I guess my question is, do you have the authority to extend? This says the hearing must be held within 60 days after the request is received. Now, one way to look at that is that the department could have issued the notice that his hearing was on the 31st first, okay? And therefore been within the 60-day period under the statute. And then, if that wasn't gonna be convenient for council, then you could have entered into an agreement to extend it at that time. But now what you're left with is you say, no, we had an agreement to extend it, based on the correspondence. And whether he knew what he was doing or not, I'm not so sure. He basically agreed to the March hearing. Okay, I can see that. But now the question is did either one of you have the authority to extend this NRS 501.1816 4B 60-day period? And do you think that the statutes you just read call for that? And is there a regulation, is there an NAC that basically says that the department can, and the parties can enter into an agreement to extend this date? Or any date in general, if there's a general provision?
All I can tell you is what I've been advised by several DAGs throughout the years is, yes, we do have that authority to enter into those agreements. And we have done so many times.
Okay.
At the convenience of.
Okay, so I guess I need to now where I'm at in this is I need to hear from the DAG as to what the authority is. This is, in my mind, we got a waiver issue here, and we got a direct statute that has a specific time period. And we have parties who have clearly gone through some correspondence to agree to a hearing date that is beyond that. And so, is there authority for for this date, the 60-day period in the statute to be waived? That's really a legal issue.
Yeah. Harry Ward, Deputy Attorney General. In a nutshell, when an entity or an agency does not have specific regulations or a specific statute controlling their administrative hearings like what went on today, you look to NRS 233B, which is the administrative code on how to have hearings. A lot of entities will adopt their own regulations and will adopt their own statutes in regards to how to have a hearing. Since NDOW has not done that, that's when you look to Chapter 233B. And under 233B, yes, you do have the right to continue matters.
Okay, now that goes to my issue that the department, should they have set the hearing for the January 31, February 1 commission meeting, and then have the 233B to continue it, or can they continue the 60-day period in the statute pursuant to 233B? Because the department didn't issue, didn't set the hearing.
I understand your argument, and it probably would have both sides. You're right. Factually, the hearing was not set. Had the hearing had been set under 233B, you could have definitely continued it. Now, stepping one step back, was it required for them to set it within 60 days? That's a determination that this commission is going to have to make up. Deliberate on it.
But it really is a legal issue as to whether, because it's a waiver. In other words, we're supposed to look at the procedure here. And if I look at these dates and I see that we set the hearing outside of a 60-day period, are we bound by that? And if we do believe that the counsel for the this Mr. Felton waived it, pursuant to these letters and going back and forth with the department, do we have enough authority to basically conclude that in a deliberation?
Let me make a generic statement. Once again, since NDOW does not have their own specific NRS or NAC controlling their hearings, you look to the 233B NRS. Now, in my experience with other entities, likewise, if I get with opposing counsel and we agree to continue a matter, it does not have to be already set by the entity. If there's an agreement, 233B permits us to say, okay, we will go ahead and continue it.
Okay, so.
Does
you're
that
saying-
answer your question? And that
And
is,
then when you say continue, you're saying continue the setting of the hearing to March as opposed to February.
correct, setting the
Under
date of the
233B.
hearing. Under
NDOW
233B,
has the authority to do that.
I would think that they would, yes.
Okay. So now all we're left with is does council have, to actually understand that? And I think my argument there is going to be that council is supposed to know the law, and so I don't know if that's going to be the defense. That's still the question. Okay, I think I've walked through this in my mind. I hope everybody was following. And anybody else have any comments? I think I've got it.
That proves why we need an attorney on this board at all times, so we can figure this out for us. Any further discussion by the commissioners? Any further comments? Seeing none.
You want to conclude it, and then we have, are we done? I mean, we're now done. We actually have to have deliberation.
We're at I.
Yeah.
Commission deliberate, render an orally is.
Correct. Once again, Harry Ward, Deputy Attorney General. If both counsel and opposing counsel have finished their arguments on the motion to dismiss, which I believe was the last, which you heard last half hour, 45 minutes, I think then we would go into the commission will deliberate, and like I said, it will be an open meeting law, there will be open deliberations, and that's where we will be.
Okay.
If there are no further questions concerning the motion to dismiss, any opposition for the motion to dismiss?
Let's take a 10-minute break and figure this out.